went home, I was like, shit, I'm all alone here.
I know why. I mean, it is your story.
Well, I'm sitting here as a guy who sat like through 4 hours of federal court of appeal hearings this morning at home.
Oh God.
Wasn't leaving the house.
I crashed the fisheries committee just now. Like, where's the privacy commissioner? Yeah, literally, I'm like out of breath with all my equipment.
What the fuck?
Everyone's looking at me like I'm insane.
I love that.
They're like,
Bonjour, bienvenue à la conférence de presse avec le commissaire à la protection à la vie privée. Welcome to the press conference with the Privacy Commissioner of Canada. You can go ahead whenever you're ready.
Merci, good afternoon, and thank you all for being here today. The distribution of intimate images and videos without consent is a growing societal problem. With a simple click of a button, someone's intimate content can be instantly uploaded and made available to millions of people all over the world on the internet. The non-consensual disclosure of such highly sensitive and intimate content, whether it be personal images or videos, can have extremely harmful consequences for victims. I call this image-based abuse because that is what it is, a form of abuse using your image. This form of abuse would be considered harmful content under the newly tabled Online Harms Bill C-63. But this abuse is also a serious privacy violation, and organizations currently have obligations under privacy law to take reasonable steps to prevent and remedy such violations. Indeed, it is difficult to imagine a more serious privacy violation than the non-consensual sharing of intimate images or videos, because it touches some of the most sensitive personal information and leads to some of the most devastating harms to the victim's dignity, reputation, health, and well-being. Today, I'm releasing the results of my investigation into Montreal-based ALO, formerly known as MindGeek, following a complaint from a woman whose ex-boyfriend had uploaded an intimate video and other images of her, along with other identifying information, to Pornhub and other ALO-owned websites without her knowledge or consent. Following these non-consensual uploads, she subsequently began receiving unsolicited messages from strangers around the world. À la demande de la plaignante, ALO a d'abord pris des mesures pour retirer le contenu en question. Toutefois, les mesures de protection de la vie privée mises en place par l'entreprise n'ont pas empêché la vidéo d'être téléversée à plusieurs reprises sur les sites web d'ALO, où elle a pu être téléchargée et probablement diffusée à nouveau. La plaignante a finalement eu recours à un service professionnel de retrait, ce qui a entraîné la suppression de ces images d'environ 80 sites web où elles avaient été republiées à plus de 700 reprises. Cependant, même après cette intervention, le matériel a continué de refaire surface en ligne. En raison de cette perte de contrôle permanente de ces images intimes, la plaignante vivait constamment dans la peur et l'anxiété. Notre enquête a permis de constater un manque préoccupant de mesures de protection de la vie privée, compte tenu de la quantité importante de renseignements personnels de nature très sensible dont ALO a la gestion, et a permis d'établir que l'entreprise avait enfreint la loi fédérale sur la protection des renseignements personnels dans le secteur privé au Canada. Our key finding is that ALO had a legal obligation to obtain the complainant's consent directly from her and had failed to do so. We found that ALO's consent model, which relied on the uploader to attest that they had obtained consent from each person who appears in uploaded content, did not constitute reasonable efforts by ALO to ensure that meaningful consent had been obtained from those persons. We also found that when individuals whose intimate images had been posted without consent asked ALO to remove the content, they were faced with an extremely onerous and ineffective process that exacerbated the emotional toll on those victims. I made a number of recommendations, including one, that ALO immediately stop sharing user-created intimate content until it adopts changes to comply with privacy law, including measures to obtain express meaningful consent directly from each individual who appears in uploaded content. That ALO adopt measures to verify that content is obtained from the individuals appearing in the content and that those individuals are of an age to provide consent. And that ALO delete all content for which valid consent had not been obtained directly from each individual. ALO has disagreed with these findings and refused to commit to implementing my recommendations. Bien qu'ALO ait apporté des changements à ses pratiques en matière de consentement dans les dernières années, l'entreprise n'a pas fourni au commissariat des éléments de preuve démontrant qu'elle avait obtenu un consentement éclairé directement de toutes les personnes apparaissant dans les images et les vidéos qui sont diffusés sur ces sites Web. Lorsque mon rapport de conclusion d'enquête était sur le point d'être achevé en mai dernier, ALO a demandé un contrôle judiciaire à la Cour fédérale afin de contester nos conclusions et nos recommandations et de nous empêcher de terminer et de publier le rapport. ALO n'a finalement pas obtenu gain de cause et c'est pourquoi je suis en mesure de publier le rapport final aujourd'hui. In conclusion, the inadequate privacy protection measures on Pornhub and other ALO sites have led to devastating consequences for the complainant and other victims of non-consensual disclosure of intimate images. This must be addressed now. Privacy is a fundamental right in today's digital world where information is shared instantaneously and in many cases lives online forever. Organizations need to ensure that valid consent is obtained, especially when dealing with content as personal and highly sensitive as intimate images and videos. I would be happy to answer your questions.
We will now start the question period. For people using Zoom, please use the raise hand function. We'll start in the room. Christopher?
Good afternoon, Commissioner. The question I had was, can you quantify how much of the content that is uploaded to ALO's various platforms does not meet the consent level that you think the law requires? Is it the vast majority? Is it a small portion? How much are we talking?
Well, our key finding is that the consent should be obtained directly from the person whose images are being shared. Right now, the model that is being used relies on the uploader. And so that was our first recommendation. We're calling on ALO to change that and to seek directly from those individuals that consent. And to this day, that has not been agreed to by ALO. And so there are measures that exist, but they rely on that third-party uploader. And our report has found that the interest of the uploader will not always be the same as that of that person, as was the case in this instance. We sometimes refer to this as revenge porn. So there are gaps, and we have found that the measures that ALO had in place, both in 2015 and more recently, are not sufficient to protect those individuals who are not consenting to that distribution.
So does that mean that neither you nor the company knows how much of the content the individuals in the content have consented to? Like, as in, I understand that their model is you click a box when you upload it and you say everyone here is consenting, which might not be true, but is there, your report talked about an audit that I was somewhat confused about. This 70% of content was not, can you kind of explain?
That's right. Well, that was one of the concerns that we had, because the model that was modified by ALO more recently provided that uploaders would have to provide documentation about the consent of that other person, and they had 2 weeks to do that. So we found concerns with that because first it was online for 2 weeks. If individuals did not provide that documentation, the harm would still have been done. And in our report, we received information from ALO employees that in 70% of cases, those documents were not forthcoming. And so that was a concern for us, and that strengthened and highlighted our key point, which is you need to go to the person that is directly affected by this. Relying on a third party providing that, and certainly providing it later, is problematic. Now again, ALO has modified its practices to some extent. That 2-week period is no longer, as I understand, applicable, but nonetheless, they continue to rely on uploaders as opposed to going directly with the person whose information is at issue.
I don't know how, yeah, okay, thank you. You said that ALO rejected these findings. You know, I guess what happens next? Is there some level of enforcement that could be done? Can the federal government take any steps to protect future victims of revenge porn?
So under privacy legislation, which I hope to see modernized and updated, there's a bill currently before Parliament, Bill C-27, which would give my office and myself order-making powers. And so that would solve a situation like this one, where these would be orders, they would be binding, C-27 also provides for financial penalties in appropriate cases. Right now, under the existing law, I don't have those powers. I can make recommendations as I have, and I'm looking forward to hearing from ALO, and hopefully that they will agree to implement those recommendations. If they do not, then there are other steps where I can take action before federal court and seek remedies there. And so we will be contemplating all available options, but certainly hope that ALO will reconsider its position.
Thank you. And then I guess my follow-up question, was it just focused on ALO because of that initial complaint, or are you also looking at other porn companies currently?
Well, this complaint was focused on ALO. We received a complaint about it, and it is a major owner and operator of many websites, and some of the most popular and visited websites on the internet. So it's focused about them, but certainly the principles and the recommendations and the findings that we make with respect to what type of consent is required in situations like this, what types of takedown mechanisms are required, what types of privacy culture and accountability that we want to see, those would apply to any social media organization. And so they should take note of those conclusions, and they should apply them to their own operations if they are not already doing so.
Thank you. We'll now check online. If there's any question, please use your raise hand function right now. In the meantime, we can come back in the room. Christopher?
So I'm curious, ALO has argued repeatedly, and including in front of the court, that they made a number of changes to their policies beginning in 2020. Is it fair to assume that you are unsatisfied with the breadth of those changes to their safety policies, and that they do not still meet PIPEDA requirements?
That's correct. So we've made a number of recommendations, and I can read them in full, but they're in my report, and you can see them. The first one, again, is to stop the collection until they can obtain this direct consent from individuals whose intimate images are being posted. We are also requiring deletion of information that would have been done in the past, because, again, even if the procedures are improved from now on, you still have to look back and see what harm has occurred in the past and remedy that. So to date, they have not met the expectations that we have in the report. I certainly look forward to hearing from them in terms of proposals, in terms of changes. We noted that certainly since 2015, since 2020, there have been improvements. There are more mitigating measures. But really the theme that we have is that some of them continue to rely on uploaders. Some of them continue to have error rates that are too high. We talked about that 70%. They're also relying on human moderators to look at the sites. We found there was upwards of 500 a day to find red flags and so on. We feel that given the significant harm that individuals such as the complainant suffered in this instance, that express consent is appropriate, and that indeed express consent would be a very strong risk mitigation measure that would prevent as opposed to address. Now, in terms of addressing it after the fact, that's important. That's where we're talking about takedown mechanisms. We also found that those were deficient. They were putting an onus on the complainant, on the victim, to identify each and every site and each and every instances of their image that they may not know about because they were not consenting to this. And as we found, they could be re-uploaded and re-downloaded. And it would re-victimize those individuals. So we made recommendations that ALO had to take proactive responsibility for this. But really, the ideal is that you prevent it at the outset.
Would your recommendation that they remove all content that is currently on the website that did not receive the level of consent from the individuals, would that essentially be for them to remove the vast majority of the content on their websites currently?
Well, that's for them to identify and to address. I think that proactive vetting, if they can obtain that consent, we're not saying that this should never be there. If there's consent, there's consent. Our concern is that there is a model now that relies on uploaders that has led to situations where individuals did not consent, had their intimate images posted for the world to see, and that the mechanisms at the front end and at the back end are not strong enough. And so we are making these recommendations in order to comply with the law. These are organizations that are operating in Canada, that have a significant level of clientele in Canada. They have obligations, and we have to remember that privacy is a fundamental right. We have to remember that, imagine ourselves in these types of situations with these most intimate images against our consent being posted all over the world. This is a high risk, very, very sensitive information. There are other measures that are being taken in Parliament to address that, but currently privacy law exists. It provides protection for these types of things, and we're going to continue to be active in this space.
Mickey?
Thank you. I guess what sort of timeline are you looking at in hopes of them implementing these recommendations, and will that at all play into your decision to take further action?
Well, we're issuing the decision today, so we will give some time to the organization to consider it. But they have known about these recommendations for some time, and so we will be certainly looking for some quick movement on that, and we'll consider our options to move this forward.
Thank you. And then I guess, what do you make of the report being blocked for a year, and then finally today the public can see it?
Well, we opposed this application in court, and we're happy to see that today the Federal Court of Appeal agreed with us, and we're now able to make this decision public. But I certainly hope that we can use this precedent so that this doesn't occur in other situations in terms of preventing decisions from being rendered in the application of the law.
Considering that they're still arguing you don't have jurisdiction, like the underlying judicial review is still active, does that give you any hope that they do actually intend to take your recommendations seriously? Because it feels like they still don't think that you were in the right to publish any of this in the first place.
Well, I will never presume intentions. I made the report. The recommendations are there, and so I will give them an opportunity to consider them. Raising jurisdiction is something that organizations are entitled to do in the context of cases and complaints, and so we've made our findings on that, finding that we have indeed jurisdiction. I'm not suggesting it's inappropriate to raise that. We considered their arguments, and we made a finding on that, and now I hope that they will review carefully those recommendations, and certainly in the interest of Canadians that we can see a resolution in short order.
You mentioned at the end of the report that you hope that this serves as a guideline for other similar platforms. For example, I was looking, there's a platform called XNXX, which is roughly as popular as Pornhub, but is not involved in this, right? If you were to seek an order at the federal court, would you hope for it to capture all such adult, or is it really only going to be focused on ALO?
Well, my goal as Privacy Commissioner is to prevent violations of privacy, is to promote understanding and knowledge. There are compliance mechanisms that can be used, and they need to be used in appropriate cases. But the purpose and one of the benefits of those reports of findings is it tells all organizations what is the law, what are the expectations. We can issue guidance. There are other means where we can communicate this. Under proposed Bill C-27, there would be even more detailed mechanisms in terms of approving codes of practices and certification programs. So I look very favorably to these things, and my hope is that organizations are not going to wait for a complaint being filed by individuals or initiated by myself, but will rather take note and apply those and build this privacy culture in those organizations. But certainly, whether it's a report of finding from my office or a decision from the court, these are looked at by organizations and by their legal teams and by their privacy teams as it should.
Thank you. No more question? Perfect. Let's conclude the press conference. Thank you.
Thank you.